الحمد لله رب العالمين حمدا يوافي نعمه ويدافع نقمه ويكافئ مزيده. فيا رب لك الحمد حتى ترضى، ولك الحمد بعد الرضا، لك الحمد كما ينبغي لجلال وجهك ولعظيم سلطانك. سبحانك لا نحصي ثناء عليك أنت كما أثنيت على نفسك. فاللهم أخرجنا من ظلمات الوهم وأكرمنا بنور الفهم، وافتح علينا بمعرفة العلم، وسهل أخلاقنا بالحلم، وجعلنا ممن يستمعون القول فيتبعون أحسنه. اللهم اجعل أعمالنا خالصة لوجهك، ولا تجعل فيها حظا لغيرك يا مقلب القلوب. ثبت قلوبنا على دينك، فاللهم لا تحرمنا خير ما عندك بشد ما عندنا. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم. الحمد لله رب العالمين. فالسلام عليكم ورحمة الله وبركاته. How's everyone? Alhamdulillah Rabbil Alamin. So we continue. And we're still reading Islamic Contract Law, and we said that we distinguish between Islamic Contract Law and Islamic Finance. And Islamic Contract Law has got to do with those underlying contracts that govern the way that we exchange wealth between one another. We mentioned many such contracts, but we are going to discuss only one of these contracts, and that is the conventional sales contract. In order for the conventional sales contract to be valid, then certain parts must exist in certain ways. These parts we have termed as integrals, and their ways we have termed as conditions. As for the parts, then the first of them that we have mentioned is that of the contracting parties, consisting of the buyer and the seller. And we have stipulated some conditions for them. They must have unrestricted contractual capacity. They must not undergo coercion without just cause or due cause. And na'am. Then in addition to that, we stipulated that if a person wants to sell a Quran or the like, then the buyer must be a Muslim. And if they want to sell weapons, then the buyer must not be at war with Muslims or belong to such a state. Then we moved on to the idea that the buyer can either do this himself or he can appoint an agent or a proxy. When the buyer or the seller does appoint an agent or a proxy, then we stipulate the same conditions for the agent as we stipulated for the original contracting parties. We moved thereafter we moved on to the contracted item, which consisted of the commodity and the counter value. And we stipulated 5 conditions over there: that it must be pure, that the essence must be pure. If it's sullied with filth, we will allow its sale. Thereafter, we said that it must have a utility. That utility will have a tangible measure, and that tangible measure might have a threshold. If the tangible measure is found and the threshold is found in that the benefit can only be accessed in a certain quantity, we will stipulate that it must be sold beginning at that quantity. Then after we have measured this, we have found the tangible measure, we will then see, does the Sharia consider this benefit? If the Sharia does, we allow it to sale. If not, then not. Then we said that the contracted item must be owned by the person who is contracting, right? Or the one on behalf of whom someone is contracting. So either the person will sell it themselves, or the agent will sell it for them. When the agent is selling it for them, then we will stipulate that they must own it, right? Thereafter, we said that it must be possible for the contracted item to be handed over. Not that it needs to be handed over in the contractual sitting, but there must be a possibility of this taking place. Then we said that the contracted item must be known in all aspects. And we said that the default meaning of it being known is that it must be seen. If that is not the case, then we will require a description which will make known its essence, which will make known its qualities that specify it from other products, and also the quantity that is being traded. When these conditions have been met, and then the contracted item can enter into the sale. Thereafter, we said that certain contracted items or commodities, right, fall into a special category that are usurious, right? In fact, before we got to that, we spoke about the contracted item being a usufruct, and we said that that's possible, and there are limited examples. There are, for example, buying the right to use a particular road that is between two homes. The right, the person can sell that right permanently, which is in the form of a usufruct. Right, if it's musha, if that wealth is owned between them. Then we said that the person can also temporarily sell the usufruct, and this will be facilitated by a different contract, and that's the hiring contract. Right? Thereafter, we spoke about the user's commodity. And we said that the user's commodity exists via the prophetic narration in 6 categories. These 6 categories can be put in 2 groups. Group 1, we found that they are gold and silver. And group 2 is wheat, grain, rice, and dates. Right? Group 1 would be currencies in terms of the thing that gathers them, and group 2 would be staple foods in terms of the thing that gathers them. Then we determined that this can be extended to other such goods, and we discussed jewelry, and we discussed the opinion of Ibn Taymiyyah as well as that of Ibn al-Qayyim in relation to jewelry being considered as a normal commodity on account of manufacturing, though we said that this falls out of the 4 madhahib, right? And that would have been the last thing that we discussed over there. So today we come to the formula, right? So we said that there are 3 main parts to the sale: the contracting parties, the contracted item, and the formula, right? If you wanted to, you can say there are 6: the buyer, the seller, the commodity and the counter value, and the offer and the acceptance. So today we've reached the formula. So Malna says, a sale, as is obvious, does not enact itself. Right? What does that mean? That means that just because you want to own something, right, or you want to relinquish your ownership of something in lieu of owning something else that is with someone else, just because that desire exists within you, right, does not mean that that reality comes into existence, right? So in order for this reality to come into existence, right, a sale must be enacted. It doesn't enact itself, right? Therefore, the sale has to be enacted or brought into existence. The enactment of a sale, which is the actualization of the will of the buyer and seller to enter into a sales contract, can occur either verbally or through action, right? The latter is what scholars refer to as mu'atat sales. Mu'atat sales, right? So we've chosen not to translate this word mu'atat because we don't have to, right? We're not shackled by the need to produce Anglo-Saxon parallels for everything. So we anglicized the word and we called it mu'atat sales. This is what it's called. So in general, a sale requires 2 verbal utterances. One of those utterances will be an offer, and the other will be an acceptance, right? But if we look to our reality, then we find that in most instances, we can go through our day shopping without saying a word, right? Without saying a word. What do we make of these sales? Where the Shafi'i school is stipulating that there must be a verbal utterance, right? So when there is no verbal utterance, right, and a sale takes place, and the actions indicate to the willingness of both the buyer and the seller, we call this a mu'atat sale. We call this a mu'atat sale. Mu'atat sales refer to the phenomenon where the seller hands the goods to the buyer and the buyer hands over the counter value to the seller without either of them exchanging any words. Imam an-Nawawi permits this type of exchange in relation to all transactions, wherein people normally enact them without having a verbal exchange. Right? It says, the Arabic goes, فِي مَا يَعُدُّهُ النَّاسُ بَيْعًا. So this is what is called the ikhtiyar. This is what's called a ikhtiyar. So there are certain scholars in the madhab, the likes of Imam an-Nawawi, that there will be the documentation of the views of the Shafi'i madhab, but then he will have his own views that exists outside of the official views of the madhab. So you call that the ikhtiyar, from the word khayr. So ikhtara yakhtaru means to choose. So there are certain masail, there are certain matters where the Shafi'i madhab goes a particular way. And because Imam al-Nawawi is the muhaqqiq, right? He is uh, the muhaqqiq. I have no idea how to translate this word. Essentially, he is responsible for officiating the views of the madhab. So you find that in the development of the Shafi'i school, that Imam al-Shafi'i, he has, so Imam al-Shafi'i, for example, is in Makkah, he has certain views, right? And then Imam al-Shafi'i he travels to different places, right? And the collection of his views before he gets to Egypt will be considered al-madhab al-qadim, the old madhab, right? And then you will have al-madhab al-jadid, the new madhab, which Imam al-Shafi'i would have changed certain of his views when it comes to when it comes to Egypt, to Misr, right? So then there will be people who transmit the madhab from Imam al-Shafi'i, the likes of Rabi' al-Sulaiman, etc., right? Then there will be those who transmit the madhab from Rabi' and Harmala and other of the main, like four main students of Imam al-Shafi'i, right? But in this time, you still have mujtahidun. You still have independent jurists, right? Meaning that you still have jurists who can, if they wanted to, have their own school of thought, right? But the more they look into the madhab of Imam al-Shafi'i, they realize that we keep coming to the same answers as him. So instead of having their own madhab, they join the madhab of Imam al-Shafi'i, right? So you're going to have the likes of Abu al-Abbas ibn Surayj and, okay, I'm not going to say the names as if they mean anything to you, right? So you will have these scholars that come sort of in the first 100 years, maybe up to 200 years, right? That are transmitting the madhab from Imam al-Shafi'i, but there's going to be a whole lot of views. There's going to be certain views that are restricted to regions, for example, Khurasan, which is in the Transoxanian region, Mawara Nahar. Then you're going to have certain views that are restricted to like the Iraqi region and so forth, right? And then all of these people will be considered to be Ashabul Wujuh. Ashabul Wujuh means that they have views in the madhab. They're kind of independent scholars, but they're also not independent because they've submitted to the madhab. So these will be different views that are an interpretation of Imam al-Shafi'i's legal theory, and they would come out to certain answers. Sometimes they will have like two options for one thing, where they'll say, look, this is a new case. We can either build this case on this case, or we can build it on another case. If we build it on this case, this will be the answer. If we build it on that case, that will be the answer. Then you will have what they call hikayatul madhab. Something like, if the view is transmitted from this case and then it finds itself in that region, then you find it becomes popularized there, whereas a different view becomes popularized somewhere else, and there's a dispute. What exactly is the madhab and so forth. Now, this goes maybe until the time of Imam al-Haramain, in the 400s, the teacher of Imam al-Nawawi, and he writes his big book. I think it comes in about maybe about 20 volumes or so, right? Nihayatul Matlab. And he gathers all of the views of his time. Then you get Imam al-Ghazali, and Imam Ghazali, after him, he writes a few, like he writes, he first writes like Al-Wasit, Al-Wajiz, Al-Kabir, and then, not Al-Kabir. So he writes all of these books, which are like smaller forms of the Nihayatul Matlab, which gathers all of the views of the madhab, right? But still, there's no idea of what the position of the madhab is. They are the views of all these jurists. So Imam Ghazali will go, and eventually after Imam al-Ghazali, they will come Imam al-Rafi'i, right? And Imam al-Rafi'i will do something where you will gather the views of the madhab, and now he will start to state what the madhab is. But when he does this, then predominantly he will base it on what is called akthariya. You will see that which view do most scholars hold, then he will consider that to be the madhab. Right? So he'll say like, okay, here's ikhtilaf on these views, this difference of opinion. Which views do most scholars, which of the views do most scholars go with? Then he'll say that's the Shafi'i madhab. Right? Then Imam al-Nawawi will come after him. And Imam al-Nawawi will write his famous book, Minhaj al-Talibin. And in Minhaj al-Talibin, Imam al-Nawawi will do three main things. He'll say, look, I'm going to tell you what the madhab really is. Why? Because the madhab, the Shafi'i madhab was never based on who says on popularity or on democracy. We all vote that this is the mas'ala. No. It's something called quwwatul madrak. So Imam now is going to change the yardstick and he's going to say that this is now a generalization of what happens, right? And now he's going to change the yardstick and he's going to say, look, we are going to look at quwwatul madrak. What is the level of the dalil? So sometimes you will find that most scholars hold this opinion, but it's because most of them come from a certain region and they have the same teacher. So they will all be considered Jahabi, they're great scholars, but they all have the same teacher. For example, they have Ibn al-Muqri or Al-Qadi Hussein or Imam al-Haramain. So they all take this view because they come from this region and this is their teacher. So when this region produces a lot of scholars and they all become great scholars of the madhab, it looks like a lot of the scholars of the madhab are going with this view. But it's just transmission from the teacher. So Imam now is not going to look at that. Imam now is going to look at something called quwwatul madrak. What's the strongest dalil on this matter? Right? And so according to this, Imam now is going to set out also a terminology of the madhab. So you'll have something called like al-asah was-sahih. So if something is asah, it means that it has a stronger dalil, a stronger proof. But it also indicates that the proof which is opposing to it is also strong and you can give fatwa on it as well. And then you get something called sahih, which will have a strong proof, but the opposing proof will be weak. Such that you can't give fatwa on the, what you call it, the muqabil sahih, the opposing view of the sahih. Sometimes the asah will have more than one opposing view. You understand? Then all of these opposing views will be muftabi. You can give fatwa according to it, but not the same with the muqabil sahih. And then you will have the adhar. So all of these views, when it come about asah and sahih, would refer to the views of ashabul wujuh, those who produced fiqh after Imam al-Shafi'i. If there's ikhtilaf in the qawl of Imam al-Shafi'i itself, then you will call it like al-adhar. And so these are some of the terminologies. So essentially, Imam Nawawi will be responsible for officiating the views of the madhab. Right? So he will do this in his kitab, Minhaj al-Talibin. Then there will come scholars after him that will, like the likes of you will, yeah, Ibn Hajar and Imam al-Ramli, right? And maybe al-Khatib al-Sharbini and so forth. Then they will write their famous commentaries, Nihayat al-Muhtaj, Tuhfat al-Muhtaj, Mughni al-Muhtaj, right? And these will be the main law books of the madhab. Then you will find certain regions will take certain books as this is the law. For example, in Egypt, they might say, look, we're going with Ramli. In Hadramaut, they might say, look, we go with Ibn Hajar, for example. But essentially, Imam Nawawi is responsible for telling you, this is the madhab. Still, is going to have certain views that's outside of that. So that you call the ikhtiyarat of Imam Nawawi. Right? The select views of Imam Nawawi. Right? So there's a little bit of history for you regarding the fiqh. So this is one of the ikhtiyarat of Imam Nawawi. So he says, what's the ikhtiyar? The ikhtiyar, the choice of Imam Nawawi in this view is that the official position of the madhab is that there must be a verbal exchange. Imam Nawawi says, no. There's a qaida. I'm not saying Imam Nawawi builds his case on this, but there's a qaida, there's a legal maxim that goes, al-adatu muhakkimatun, right? That the law brings about, the norm brings about law. The norm brings about law. So we discussed this matter. What is this matter? This is something that we discussed a lot with Ml Muhammad Carr over the last few days, or like before we came into i'tikaf. It's the idea that when we write down the law as a means of capturing a legal reality. But our capturing of the legal reality will never be the reality. Right? So, when we wrote down what a sale is, a sale first existed physically. Then we gave that construct, right, a legal delineation. So, whenever the Shafi'is wrote down what something was, then they built all of their fiqh on that, regardless of how it looked. That's why you'll find sometimes the Shafi'i madhab is very extremely logical, but sometimes can be impractical. The Hanafi madhab is different because they first produce the views and then they write down the theory. Right? So Imam Abu Hanifa, he doesn't write down his usul al-fiqh and then give his students the law. He just discusses masail with his students. Then his students afterwards distill the principles that he was using from the law. Whereas Imam Shafi'i, he writes a legal theory manual and then he teaches that to his students. And then he goes through the fiqh with them on how to apply the manual. That's why you find the Shafi'i madhab would seem to be more methodical, right? But that also has a dryness to it, right? So Imam al-Nawawi, in recognition of this, says that, look, man, that the sale has a reality, and the reality is taradi. The reality is that there's mutual consent. If this exists in a way that is socially acceptable, and that doesn't contradict the Sharia, then we will accept it. Then we will accept it. So this is فِيمَا يَعُدُّهُ النَّاسُ بَيْعًا. Whatever people consider a conventional way of having a sale, without the Sharia proscribing that, then we'll accept it. Right? This is in terms of the conventional sale. Now, so the official view of our school of thought is that the sale cannot occur in this manner. Instead, the buyer and seller must exchange words for the sale to be enacted. From the seller's perspective, the statement is referred to as the offer. The offer, according to the Shafi'i school of thought, can only come from the seller, regardless of whether he speaks first or replies. So only the seller can make the offer. Right? Meaning, if you come and you say, sell me this phone, then you will have to say, I sell you this phone. You see that? So the words give an indication of his volition to sell. That's an offer. You understand that? Whether he speaks first or he speaks second, you will speak in such a way that gives the purport of the words is that he wants to sell. He's offering to sell. Right? So that's why sometimes they say an offer to buy and an offer to sell. They don't say an offer and acceptance. It's an offer to buy and an offer to sell. Right? This can either be explicit or it can be implicit. We're on page number 49. As saying, I sell to you, or I make you the owner of. Or it can be implicit, such as, I make this over to you, or this is yours for 1,000 rands. Right? Now, these meanings are some of the difficult meanings in the Sharia when it comes to words. Because this is written from the perspective of Arabic. You find this challenge in talaq also, where the person says, I talaq you. So this is an issue that is discussed in the books of fiqh, but primarily it's built on the Arabic construct of words. Right? So when you say, I sell to you, I make this over to you, the meanings are very close in Arabic. Whereas when I say, bi'tuka, malaktuka, it has clear implications, right, in the Arabic language. Or when I say a'taytuka, that has different implications, right? So malaktuka comes from the word malik, milk, ownership. So when you put it on the second scale, malaka, to make the owner of, right? When you say bi'tuka, that is a clear implication. When you say ishtaraytuka, has a clear indication of selling. Right? But when you say a'taytuka, I give you, then that doesn't give a clear indication of selling. right? So the idea is that when the indication is not clear, then there must be a niyyah to sell. When the indication is clear, it will suffice in enacting the sale, right? So the next thing that Mana wants to say is that the acceptance is the statement of the buyer. For example, I buy from you, or I take ownership of, or I accept, right? So that's the idea. Now Mana is going to speak about the concept of mutual consent, right? So we're not talking here about consent like, there's a lot of controversy around the word consent in the modern age. Because now you must have like consent, mathalan, to have conjugal relations with your wife. And so now you can have something like marital rape. And it's a fairly new discussion, right? Anyways, mutual consent over here refers to both buyers want to buy and sell. And this goes back to the idea of coercion. Goes back to the idea of coercion. And it also comes to the idea of what we mentioned in the beginning of the class, that the idea of mutual consent is a metaphysical idea. You cannot see it, right? Therefore, it has to be made manifest. It has to be made manifest. So that's why Allah subhanahu wa ta'ala says, Ya ayyuhalladhina amanu la ta'kulu amwalakum bainakum bil batili. Oh, you who have, oh, you believe, to devour not your wealth between you through falsehood. Right? Illa an takuna tijaratan an taradin minkum. But only through trade by a complete mutual consent. Right? So mutual consent resides within the hearts of the contracting parties. However, for the sale to be valid, this consent must also be outwardly expressed, as the Lord takes what is apparent into consideration. Right? In completion of this, I say, and success is from Allah, specifying a verbal argument or specifying a verbal agreement is the most explicit means of demonstrating the internal desire of both parties to exchange wealth. So there are many ways to express that you actually want to hand over ownership and take ownership of something else. That can be by you picking up something and giving money, right? That can be by you nodding your head. That can be by you smiling it off, or a Facebook post, for example, right? Or in the case of the vending machine, which is a debate that Mufti Taqi Uthmani has, by you putting the vending machine there, plugging it in, filling it up, it's an indication that you want to sell, right? Though, but the clearest of all is when you actually say, I sell you. And then the person says, I accept. Or a person says, I buy from you. And then he says, I sell to you. Right? So this is the clearest form of indicating that mutual consent actually exists. Though it may be more cumbersome in the sale of trivial goods. Right? So you find that scholars go different ways in terms of this mu'atat. Imam Nawawi, in his majmu', he doesn't differentiate between types of goods. But other scholars, I think the likes of Ibn al-Muqri, he will say, look, we will permit it in the sale of trivial things, but not in the sale of large items. In the sale of large items, we'll say that, or extremely expensive items, we'll say there must be a physical agreement, right? Or there must be a verbal agreement, right? And he says, in our local custom, engaging in mu'atat sales for trivial items is common. Practicing upon this personal view of Imam Nawawi from the Shafi'i school essentially mirrors the official view of the Maliki school, and Allah knows best. So what happens over here is that when you practice on the select view of Imam Nawawi, you are in fact at the same time practicing on the main view of the Shafi'i madhab. Of the Maliki madhab. So this will not be the view of the Shafi'i madhab, right? But within the Shafi'i madhab, we have Imam Nawawi, and this is his view, right? So this is a view of a select scholar in the Shafi'i madhab, but it is the official view of the Maliki madhab, right? So you can say, look, I'm actually practicing the Maliki school on this one. Actually practicing the Maliki school on this one, right? Then after you engage in that sale, you can make irsal also Make salah like that, leave your hands down. Right? And people ask you, what's going on? You tell them, I'm Maliki, I engage in mu'atat sales. Right? طيب. So what did we say? Question after class. Right? So what did we say? We said that we discussed the formula. In terms of the official view of the Shafi'i school, the formula must be a verbal utterance. And that will be an offer from the side of the buyer and an offer from the side of the seller, right? Or an offer from the side of the buyer and an acceptance from the side of the seller, right? Both of these constructs exist. This can either take place explicitly via saying, I sell to you, or I make you the owner of, or it can take place implicitly, such as saying, I give you this for such an amount, or I make over to you this for such an amount. When it takes place explicitly, that will suffice in enacting the sale. When it takes place implicitly, then that will have to be accompanied by a niyyah from the buyer or a niyyah from the seller, that they actually want to engage in the transfer of wealth and the ownership thereof. Then we said that in terms of the norm, people don't enact their sales via verbal utterances. So how do we construe of this? When we look within the madhab, we find Imam al-Nawawi. And Imam Nawawi has a view wherein he permits mu'atat sales, which are sales that occur in such a manner that normatively the two contracting parties will be considered to have agreed upon something, though they didn't utter words. Right? Then we said that when we practice on this view, though it is a select view of a scholar within the Shafi'i school and not the position of the Shafi'i school, it is in fact the official position of the Maliki school. Right? And that's that. So in the last 8 minutes, let us define for you what a sale is. Let us define for you what a sale is. Through previously being exposed to the integrals, conditions, and different forms of sale, you now know that a sale can be defined as what? How to read the Arabic? Because, I don't know, there's a bit of a tricky translation. What does it say? مقابلة مال بمال لا على وجه القربة تفيد ملك عين تأبيدا أو تفيد ملك منفعة مؤبدة. Right? So how do we translate it here? The exchange of wealth. We're on page number 51. The exchange of wealth for wealth. Notice how we didn't say money for money. Because mal, the Arabic term mal, right, is money and more. Money and more. So we'll refer to money as fulus, or we'll refer to it as nuqud, right? Which is only one form of wealth. It's only one form of wealth, right? طيب. So the exchange of wealth for wealth in a non-charitable manner. In a non-charitable manner. What do we mean thereby? We'll come to discuss it. Resulting in the permanent transferal of the ownership of a corporeal or usufruct. Right? So what do we have? We have the exchange of wealth for wealth. What does that mean? That means that they can take any form. Doesn't have to be money. So I can exchange a camera for a laptop. That will be considered as a sale. Right? Then what becomes the price? They say ما دخلته حرف الباء. Whatever the preposition ba or the harf jar ba enters upon, that will become the price. So I say اشتريت بألف. I sell bi-alf for 1,000. Or bi'tuka bi-alf. I sell to you for 1,000. You see that? So that will be whenever the word for is used, what comes after that is the price. Why is this important? This is important because the price can be exchanged, but not the commodity. So the essence of the sale is the desire of the commodity. That's the essence of the sale. So when the commodity perishes, then the sale perishes. But when the price perishes, then they can renegotiate. They can say, look, give me another thing like the price, or let me swap out this price for another price. But when the commodity perishes, then there's no sale. Then there's no sale. For example, when you buy a book, right, and you pay for the book, then you don't take possession of the book, and that book perishes, there's no sale. You're entitled to get your money back. But when you buy a book and you don't pay for the book, right, but you take possession of the book and you lose the money, you can get other money. Give it. Or you can tell them, look, I don't have rands now. I'll say, okay, give me dollars. You understand that? طيب. So let's look at the Sharh al-Ta'rif. You know, oh noble student, now the Arabic student should have known this. You know, oh noble student, that the definition must be encompassing and restrictive. Is that the oxymoron? Must be encompassing and restrictive. They call jami' mani'. Including everything intended whilst excluding what is not. So what's this you call a had, right? A delineation. So there are different types of definitions, but okay, that's going to be logic. But essentially, this type of definition is the most precise type of definition. And it is intended through words to include everything that that thing is and to exclude everything that it's not. So you get something called a jins, then you get a naw', then you get a fossil, then you get a khas. Right? So a jins will be the broadest category. For example, if I say, what's a human? Then you say, hayawan natiq. An intelligent animal. So if I say, what's a human? It's an animal. It's jami'. It's encompassing, but it encompasses too much because it mixes humans with lions. So then when I say it's a talking animal, right? Then this is called a khas, where it's restrictive, but it's not restrictive enough because you get a parrot. So now, when I say it's an intelligent animal, then you only have one intelligent animal, and that's humans. So now it's encompassing and it's restrictive. That's the purpose of a had, right? Of a delineation. It's a particular type of definition. Then you get something called a rasm, which is like a figurative definition. At-ta'arifu bil-athar, where you define something via the effects that it brings about. So you say, what's fire? It's the thing that burns. It's not a quintessential definition. You're defining it via the effect that it brings about, not the reality. And sometimes to define something figuratively is more precise than to delineate it verbally, right? Anyways, this is the definition. So let's just go through this a little bit. Exchange, right? So in the Arabic, it will be muqabalatu malin bimal. The word muqabala is on the scale of mufa'ala, who's in the Mizan students, third bab. The speciality of the third bab is mutuality, right? Or reciprocity, when one thing for another, right? So when you have darb, you have hitting from one side and the other side is receiving. But when you have mudaraba, both sides is receiving hits. Isn't it so? Sorry, that is a violent example, but anyways. This signifies that the commodity originates from the seller while the counter value originates from the buyer. So there's a muqabala, there's a mufa'ala, right? There's a mutual exchange. In simpler terms, it is commutative in nature, right? It's commutative in nature. Conversely, when there's an exchange from only one party, such as the case of a gift, it's categorized as charity and not a sale. Right? So when I give something and there's no price, that's now not a sale. That's a charity. That's a charity, and that has its own contract. Has its own contract. Right? In the Shafi'i school, they might also stipulate a formula, a verbal formula for gifting. Right? But it might be carried by mu'atat also. There are other things that start out as a charity, right? But they end out commutative. For example, a loan. A loan starts out as, borrow me a 10 rand. Right? So that's a charity. Then you say, I'll give it back to you. Then it becomes commutative. You understand it? So initially, you're giving it out of your own volition and it's an act of charity. And then eventually, it becomes commutative in that there's an exchange. But though this is commutative in that, okay, commutative is not the right word over here, but though this is reciprocal in that there's an exchange, the Sharia doesn't allow it to move out of the bounds of charity. So a loan can never take place except as charity. That's why when you make something off a loan, it becomes riba. Right? So the Sharia has restricted the loans contract to being charitable. Right? Now, so that's understood? Taib. Then wealth for wealth. Wealth encompasses anything that provides benefit, whether tangible or intangible. Here, noble student, you observe that a contracted item can either be a tangible object or its utility. For instance, it would be permissible to exchange a tangible item, like a car, for the right to utilize a house for a specified period. Right? So you can do that also. You can exchange goods for services. Right? The question that I had the other day that I'm still not very clear on is that, can you exchange services for services? Right? Can you exchange services for services? So my tentative answer is yes. But you know, in the fiqh, you have a law, you have a book of law, like a manual, but then you have a commentary on that manual. Then sometimes you read the manual and you think this is the answer. But when you read the commentary, then you see that there's actually more specifications around the issue. Right? Therefore, yeah, Malna brings another case, and that uncle's not here today. He asked the question the last time about the bride money. The scholars assert that anything permissible to be sold can also be given as bride money. What's bride money? Mahr, askavi. Why don't we say, what's the other word they use? Dowry. Because dowry is what the woman pays the man. Stay with me. Dowry is what the woman pays the man. Right? This is, like we said, this is another one of those words that if we adopt it, then we unwillingly adopt the Anglo-Saxon baggage that it comes with. Right? This word exists in another paradigm of law. In another paradigm of law that is not Islamic. You understand that? So if you go to Google, right, or any dictionary that you like, did you see it? What did it say? Read it for us there.
Dowry is a payment such as property or money paid by the bride's family to the groom or his family at the end of the marriage.
See that?
Dowry contract is in his family or her family.
Mustathna.
Dowry contrasts with the related concept of bride price and dowry.
You see, even if we say, oh, his family, it's problematic. Because in the Islamic paradigm, it encompasses something that we don't mean. You understand that? So we say by her family or his family. That's not what we mean. The dowry can only come from him. The second thing is that it's not a family thing. It's a thing that the bridegroom gives to the bride. It's got nothing to do with the family. If the family gives him charity and then he gives it, no problem. Right? Or there are some other customs that family gives gifts and all. That's all outside of Islam. Right? Not impermissible outside of Islam. In that Islam doesn't require you to have it. Type. Okay, let's just finish this. There's, Mullah says here, a Quranic subtlety relating to wealth. I'm going to skip this. And then I'm going to say that in a non-charitable manner, we say that whatever is given in charity is not regarded as a sale, even if there's an exchange involved, such as loans. We explained that, right? Then permanently. This means that when it happens temporarily, then it will be facilitated by a different contract. For example, hiring. And we've been mentioning that in the classes all the time, right? That when you exchange, for example, the usufruct of something temporarily, or when you allow the usage of something temporarily, that will either be ijara or i'ara. It will either be hiring or loan for use. They use that term, right? Permanent transferal of ownership, right? This clause elucidates one of the most apparent outcomes of a sale, the transfer of ownership, right? So the last is like stating the obvious, right? But it's also the outcome of the sale. The outcome of the sale is that the transferal of ownership takes place. So I'm not going to mention the Quranic subtlety regarding wealth. Or I'll just read it with another issue that Mala brings here, then we'll end the class at that. What does he say? Allah mentions wealth and children in the Quran, differentiating between it and al-baqiyatu salihat, right? The everlasting righteous deeds. What does Allah say? Al-malu wal-banuna zinatul hayati dunya wal-baqiyatu salihatu khayrun inda rabbika thawaban wa khayrun amala. Wealth and sons are but the fleeting finery of the paltry life of this world, and immortal deeds of righteousness are better with your Lord in reward and better to hope in. He says, this differentiation is evident in the Arabic structure, where the word baqiyat precedes the word salihat, contrary to the usual order in descriptive compounds. What does this mean? That it's a mawsuf sifa, meaning that what? That the mawsuf must come, then the sifa afterwards. The described, and then the description. So it should have read, as-salihat al-baqiyat, the good deeds which are everlasting. But it comes al-baqiyatu salihat. Why this difference? This arrangement highlights the distinctive quality of immortality associated with whatever follows baqiyat. Meaning what? That when Allah subhanahu wa ta'ala mentions mal wal banun, wealth and children, and then Allah differentiates it from baqiyatu salihat, how do we know that Allah is differentiating between the two? And Allah is not just mentioning both. We know that because Allah subhanahu wa ta'ala, instead of mentioning that which is differentiated first, Allah mentions the differentiating quality first. And that becomes the boundary that separates between wealth and righteous deeds. What is that? Immortality. In that wealth is fleeting and righteous deeds are immortal. You understand that? Furthermore, describing wealth as fleeting underscores its transient nature, inherent to its essence. Now, listen to this. This is one for Sheriff. Additionally, it's worth noting that wealth is a relative concept. What holds value in one time or place may become worthless in another, and vice versa. For example, cans, irrespective of their composition, glass, tin, or plastic, were once viewed as mere waste to be discarded. However, their perception has shifted drastically, with companies now regarding them as valuable capital. These containers have transformed into the capital of companies engaged in reuse and recycling practices. These companies spend money in acquiring materials for recycling or converting them back into raw materials for various purposes. In our current time, where these recyclables are deemed as wealth, would it be permissible for you to throw your containers in the street? This is besides the fact that this causes great inconvenience to people. Also, pollution is known to have negative effects on the environment. Right? So, as it is the sheriff's point or advocate's point, because it's on a big campaign to save the planet. And we want to hear about it. I have to go there. It's got a international strategy to get a million people involved. Right. So that is that. So what did we discuss lastly? We said that we discussed the definition of the sale. We said it's the exchange of wealth for wealth in a non-charitable manner, right? Permanently, right? Which results in the permanent ownership of a corporeal or user frame, right? طيب. So alhamdulillah, we've completed that. Tomorrow we'll complete the rest of the 30 pages, inshallah. So, so after this, I'm going to speed through it, right? Because I think there's 2 days remaining. So I'm not going to summarize tomorrow's class. I'm just going to get straight into the discussions, inshallah ta'ala. وبهذا نكتفي وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم الحمد لله رب العالمين.